Hi, I'm Tom Spiegel with the Spiegel Law Firm, where we protect people who've been wrongfully fired or afraid that they might be. Today, I want to talk to you about wage and overtime protections under both federal law and Virginia law. Let's start with federal law. The big kahuna in the federal law is the Fair Labor Standards Act, or FLSA in short. And this is a very powerful statute that requires that workers be paid a minimum wage and be offered overtime if they are what's called a non-exempt employee. Which generally applies to people who are not in management. That's not, the rule's a little bit more nuanced than that, but sort of a bright line rule is if you are not in management, you don't have the right to hire and fire. The odds are is that you are a non-exempt employee, which means you get your 40-hour work week, and if you have to work over, you get overtime pay for that time. It also prevents discrimination against you for raising issues of what you believe to be unfair wage practices, even if you turn out to be wrong about that for whatever reason. So it's a very powerful law in that you can win if you are fired as a result of something that happens under the wage law. You can get your back pay. You can also get your back pay if you should have been paid more during that time, even if you're at the same employer. Right? So you can get the difference between what you are making, what you should have been making, or if you're fired, everything you would be entitled to. You can get your attorney's fees paid for, and you can get something called liquidated damages. And essentially, a rule of thumb is the court looks at that and says, we're going to take whatever the underlying award is, let's say it's $100,000, and we're going to multiply it times 2. So we're going to add another $100,000 for what are called liquidated damages, designed to punish the employer for a willful violation of the Fair Labor Standards Act. So it's a very powerful statute to protect people who are entitled to those benefits, particularly pay and overtime. Now, there's actually significant subsets of workers that are not covered under the FLSA. I mentioned exempt and non-exempt before. Many people in management or in professional positions are exempt from the FLSA. That means you don't get a 40-hour work week and then time and a half beyond that. Also uncovered under the Fair Labor Standards Act is are independent contractors. Those people who are not a W-2 employee, you usually get paid by a 1099. And with the growth of the gig economy, there are more and more people who are classified either appropriately or inappropriately as independent contractors. There are a number of reasons why companies like to classify people as independent contractors. It's a reduction in taxes for the employer. They don't have to provide the same rights and benefits as we're discussing under the FLSA to independent contractors. The rule about whether or not just because an employer says you're an independent contractor doesn't mean under the law that you are one. And there have been plenty of cases where the Department of Labor and courts have enforced sanctions against a company because they misclassified a worker as an independent contractor when really they were an employee. What constitutes an independent contractor? Generally, an independent contractor is someone who has control over how they perform the job. Right, so a classic example is a technician that shows up at your house or at the workplace. They bring their toolbox that they own. They use their tools to fix a discrete problem. They take their tools at the end and they go home. So they've got complete control over how they perform that job, generally including when they do it and what tools that they use to do it. It can also apply in like the white collar context. If you are, for instance, in marketing, and you are working with a company on a limited project and you're using your own computer, your own software, you're sending out invoices. Let's say you have an LLC, you're sending out invoices to the company and you're paid, then you are an appropriate independent contractor. The line can get blurry, however. If you are, let's say the employer requires you to come do your work at the workplace. Let's suppose the employer requires you to use their computer system. Let's suppose their employer is having you clock in and clock out. Well, in that case, you are very likely to be considered by a court or the Department of Labor a full-time or a W-2 employee entitled to all the protections that offers. So there's a lot of litigation over that, and understand that how you may be classified may not be the same way that a court looks at it. Under Virginia law, and you should keep in mind that there are state analogs in many states to the Fair Labor Standards Act, and they vary considerably from state to state. For example, the District of Columbia has a very broad Wage Protection Act that provides not only liquidated damages, but treble damages. So 3 times the violation if an employer in the District of Columbia violates a wage or an overtime law. Virginia's passed some new laws in 2020 that help somewhat. Virginia has historically been a place where wage laws, particularly state ones, are very difficult to enforce. But in 2020, the legislature did pass and signed it, and the governor signed into law some things that provide workers more protection. Right now, under Virginia law, you have to file with the Virginia Department of Labor. The law gives the DOL beefed up ability to investigate and address those claims. It prevents you from being fired or discriminated against because you filed something with the Department of Labor. So those are the protections under Virginia law. And remember, you can still bring claims under the FLSA. The FLSA is a federal law and applies to all employers across the United States. So if you think you have been wrongfully denied wages or overtime payment, you could be protected under one of these laws, and I suggest you talk to an attorney to see if you are.